All right, welcome everyone to this last session on competition law in this year, and then we're going to have some more next year. This year, the last one, I'm very happy to have Friso Bostoen here, who is currently on his Great Asia tour. He has been in Korea, now in Hong Kong, and he's heading down to Australia afterward. And we had the luck to basically tap on to this trip to have him here. So Friso is an assistant professor at Tilburg University, and he has previously been at the EUI in Florence. He holds a PhD in an LLM from KU Leuven and an LLM from Harvard. And he's basically very known for his work in the digital space. And today, he's going to talk about AI training data and how to put a price on that. And I think it couldn't be more timely to talk about this. With the EU Commission having just started a case around the questions of AI training data. So most likely you will have to now update your slides in a bit and when we see more of that coming down the way. But it's certainly an interesting time. And without further ado, over to you.
Thank you very much. Am I audible like this? Yes, I think so. Well, thank you very much for the invitation, Julian, and thanks everyone so much for attending. I know this is the end of the year. This can be a tricky time, so I all the more appreciate you being here. And I hope to make it worth your while. I'll be talking about, yes, putting a price on AI training data. Of course, the basics of this problem is well known. There's a lot of creators out there that have produced valuable content, artistic, newsworthy, otherwise, and all that content is being sucked up to train AI models, often, almost always, without remuneration, which might, over the long term, have some negative impact on the production of that content. So my question is there a way that we can sort of satisfy both, have AI training, which of course leads to something productive and useful in its own right, these AI models that I'm sure we all use, but also making sure content creators are protected. And as Julian already mentioned, we're seeing the first moves in this space. The Commission just last week, or this very week, opened an investigation into Google on the way that it collects data, crawls the internet, of course, using then that data for its AI training, and also to surface that content in Google search. And publishers basically cannot say yes or no. If they want to be found in Google search, they have to accept this, and they are not compensated. Now, such an investigation is important and interesting, but of course, it's not really a systematic solution. This likely ends with a finding of abuse and a big fine on Google, but that does not mean that any of that money flows to creators. The same with a big settlement in the US recently. Anthropic, another well-known AI developer, settled a lawsuit with the authors of books mostly. But this was a clear IP law case because what Anthropic had done was use a repository of pirated books, clearly illegal, to train its model. Now, we have a clear IP law framework with statutory penalties on a sort of per book basis, which would have added up to much more than 1.5 billion. So they chose to settle instead. Here, a couple of authors are going to see some money, that's for sure. But again, not quite a systematic solution. Everyone not part of this case goes unremunerated, and it's mostly limited to sort of the biggest authors that were able to start this case. So what really triggered us, because this is work by myself with my colleague Giorgio Monti, was a preceding case already, Kadri versus Meta. Again, authors of books mostly against Meta for having their content used in AI training. And one of the defenses, because this was a fair use case, Meta essentially arguing that it could rely on this content, but fair use, one of the conditions is that this content could not otherwise be monetized. They said, look, there is no market for this kind of content, for this data. We have a classic market failure here. And of course, as competition lawyers, when we hear market failure, we prick up our ears and think, well, is there really? Meta identified a couple of reasons. First, classic transaction cost problem. look, there's thousands, millions of creators out there. We can surely not go to all of them and conclude individual contracts for the use of their content. There's also the problem of price setting, and that's one we really zoom in on, because authors, while think their work is very valuable, they were, according to Meta, again, demanding unrealistic sums. But for Meta, I mean, one piece of content in itself is not quite as valuable. And insofar as it is valuable, it's hard to put a value on it. Now, that's the two problems that Meta pointed out. We would add a third one, which is, of course, market power. If you're a small news website, an author of a book or two, or even a couple of articles, well, you're unlikely to be in an equal bargaining position with the AI developer on the other side. And we know, of course, that unequal bargaining power can also distort the whole bargaining process and especially the price setting. Now, interestingly, Meta used this as an argument against paying creators, saying, well, it's essentially impossible. We cannot come up with a way to pay these creators, so we shouldn't be expected to. But you could flip this around and say, well, maybe this is an argument for regulation. If you go back to economics, Meta is kind of saying that the Coase theorem does not apply. Coase famously said that, well, if property rights are well defined and there are no transaction costs, then parties can bargain their way to efficiency. We don't need to intervene. By contrast, if either the property rights are not well defined or there are transaction costs, perhaps there is a case for the state to intervene here and either more clearly define property rights or solve that transaction cost problem. And this is, of course, what content creators are asking for. They also see that this case-by-case, mostly IP-based litigation is not the way forward. It costs a lot of money and only gets some creators paid. They want a more systematic solution. Similarly, policymakers from the US to the UK to Europe are sort of asking for solutions, also because they don't have them. And it's not easy to come up with a model here because, of course, we have strong interests on both sides. We do, I think, as society, want these state-of-the-art AI models that help us in all kinds of things, and over the long run might certainly help us achieve economic growth, competitiveness, and so on. On the other hand, we also do not want to disincentivize content creation. We all benefit from having useful, entertaining, high-quality content out there and want to keep benefiting from that. So if you put the balance too much on one side, one of these might become at risk, might become, at the worst case, unviable, especially if you put a high price on content data, then of course AI training itself becomes potentially unviable. So that's our starting point. There is, of course, an interesting argument saying, well, content creation, is this not a passion job? Especially in film, music, fiction writing. Don't authors and other content creators do this for fun? So even if all of their content is taken without remuneration, should we worry about content disappearing? Well, there's some interesting empirical work on this that basically says that it's a balance. Certainly a lot of the content creation, all the more so with news content and so on, is done for money. I make the case more anecdotally here from a recent interview with Denzel Washington, the well-known actor, answering this question, well, do you do it for the money or is it for something else? And he basically says, well, every job is for money. So I think that's one way to tackle this argument, saying that content creation will continue to be there. Indeed, there will continue to be some content creation, even if everything is free, but maybe not the high quality that we seek out. So a first answer to this problem is saying, well, it's a technological problem. Perhaps there are technological solutions for this. And I'll focus here on the most prominent one so far, by Cloudflare. Cloudflare is a global sort of internet services provider. About 20% of the websites globally run on its systems. And it takes care of traffic, but also crawling and the permissions for crawling. Because the way all this content makes its way to AI developers is, of course, through crawlers that they put out on the web and basically go to every website and collect that data. Now, Cloudflare helps website owners, and at one point made a complete switch saying, look, the default is now going to be that your website is inaccessible for these crawlers. You can then make it accessible again through some active choice. And you can even say that you want to be paid for access, sort of make the access conditional. Now, interesting system, of course. So far, at least, the only thing you can say as a website owner is that you want to be paid. There's no system for actually being paid, let alone determining a price. And of course, even if there is, if you leave it up to this sort of one-by-one bargaining approach, market power might distort it. So it solves maybe a transaction cost problem. There's something to be said for doing this in an automated, easy way, but you do need more than that. The other argument against this is I think that it might strengthen firms that already have market power, especially Google here. Because what happens with these crawlers, and you can see that on the right-hand side, although it's a bit small, well, it used to be that the internet was kind of open. All websites let their sites be crawled by sort of everyone, including Google, but also Microsoft's Bing search engine, for example. Now that changed dramatically with the introduction of generative AI. You can see that around 2023, 24, a lot of websites closed off, about 30% maybe. Now with the change in policy in Cloudflare that only came after this paper that I'm drawing from, perhaps up to 50% of websites are at least partially inaccessible. So the internet is closing down. And who is most harmed? Mostly the non-big tech AI developers. ChatGPT by OpenAI, Perplexity, Anthropic, and so on, because they only do AI. Of course, what Google also does is search, and everybody wants to show up in the search results still. So they have no option but to allow Google to crawl their website still. Otherwise, they disappear from search, and probably half of their traffic is gone from one day to the other. So in a system where everybody closes up their content to these crawlers, well, Google is the big winner because, as you also can see in the data, only 1% of websites still blocks Google, while for OpenAI, Anthropic, and so on, it's perhaps that 30%, 20% at least, and increasing. So again, automatic models like this, technical solutions have serious deficiencies. Now you might say, well, haven't some deals been struck already between AI developers on the one hand and content creators on the other? And that's certainly true. According to one count by the Create Center from Glasgow, upon their last count, mid-2025, there were already 83 deals out there. You can see there the developers that closed them. And on the content side, it's sort of three big categories. There's first academic publishers, Oxford University Press, and so on. They, of course, have loads of high-quality content. Secondly, social networks. Reddit in particular is an important source of training data, but also Pinterest. And thirdly, big news organizations. The German Axel Springer, for example, which has a lot of publications also beyond Europe. Now, who's paying for those? Again, here we see a bit of a competitive distortion. Google is not paying so much. OpenAI and Perplexity, the startup AI firms, of course, very well resourced, are the ones who are paying. And I think this goes back to the crawling, right? If you are blocked from crawling all these websites for free on the internet, well, you have to start paying for content to keep up with Google, who does have access to that content. So again, this kind of bilateral bargaining system where we see some valuable deals might distort competition while doing something valuable for content creation. So again, as a competition lawyer, and that is my background, maybe not the solution that I'm most happy with. So that leads us to IP law solutions. Most of the academic work that has been done on this comes from this IP law area, because they focus not so much on the transaction costs, but rather on the property rights. It is intellectual property law after all. And so their proposals focus on strengthening those rights, perhaps coming up with a specific remuneration right for content creators, specific remuneration when their content is used by AI developers. So if you had a couple of proposals there, I think the smartest ones of them do not only consider the property law question, but also the way that that is then put into practice. They often go to collective rights management. This is something we know well, for example, from music, where you have collecting societies that hold or manage at least the IP rights of musicians and other artists and make sure they get remunerated when their music is played in bars, clubs, restaurants, and so on. Now, so this gets closer to the solution, property rights, collective rights. Of course, even the market power problem is mitigated here to some extent because a collecting society is often a strong player in its own right. So when it's sitting on the other side of that bargaining table, it can do better than the single artist. But how are they going to price this? And if they don't agree, who do they go to? Those questions are still unresolved. So what we did is look at a couple of frameworks that have tried to solve this problem in the past, in a pre-AI era. Sort of the frameworks that facilitate bargaining between two parties, one of which that maybe doesn't want to come to the table or pay at all, and where in any case the determination of the price is a sticking point. And we found 4 useful ones, mostly for intangible products, so content or data. The first one are these data acts that were recently adopted in Europe. The second one was the bargaining models for press content that we've seen sort of all across from Canada to Australia to Europe. Next, the excessive pricing doctrine, especially as applied to collecting society. And finally, the pricing of standard essential patents. So all or mostly intangible content where the bargaining is somehow needs a helping hand. So let me start by going over those and sort of inductively take away from them the factors that might be useful if we do want to think about sort of an ideal system for the bargaining about remuneration for content creation as used by AI developers. Now first, the Data Act, maybe a bit of background, because this is of course an EU law, although I've been amazed at how well everyone here knows many aspects of EU law. But these data acts have been adopted the last year or two, basically with the goal to open up all that data that is sitting there unused, but that might be very useful for the purposes of competition and innovation. Now, this might, for example, be car data. There's a lot of car analytics that sits there and is mostly available to the car manufacturer. But it would be very useful if that was available to independent car repairers, for example, because then you would have more options to get your car repaired. And without the analytics data, it's very hard to do so. Of course, here, the incentive story starts to go a bit awry because, well, if you're a car manufacturer, car repairs are quite profitable. Maybe you want to keep that for yourself and not share this analytics data to make independent repair impossible. So you do need a bit of a legal push to share that data. Even those parties that are willing to share data, for example, from a connected device, health data that they're not monetizing, well, the sharing of data in itself comes with a cost. You need to come up with some interfaces. You need to move some bytes from here to there. There's some costs involved, so that too needs a little push. Now, what the Data Act says, well, first, it forces that data sharing, of course, but not for free. They say, the acts say, and there's really 2, but I'm starting with the General Data Act, that this has to happen on non-discriminatory and reasonable terms. These tend to be well known, sort of fair, reasonable, and non-discriminatory, the typical FRANT provision, but that may include a margin. I mean, first, the sharer of data may ensure that its cost is being remunerated, so anything it's invested in collecting or producing the data can be remunerated, as well as making the cost of making that data available, so the interfaces I talked about. Although there is some obligation on the data holder to mitigate those costs. You have to be somewhat efficient. But on top of that cost remuneration, they can charge a margin. And here it gets interesting because that's, of course, the incentive to come to the table and actually make this possible. You can profit from it. The margin, again, is kind of regulated, as in the margin has to be in line with the investment. So clearly a focus on incentives to invest, right? You do want to keep producing that data, make sure the data holders don't stop so they can get a margin that depends on their investment. But they cannot charge any margin to small players, small and medium-sized enterprises, SMEs. So here also a sensitivity to market power. Maybe the big ones can pay more, get a margin of them, but the small ones get a free pass. And in fact, the very largest ones cannot benefit from data sharing at all. Gatekeepers, a concept from this Digital Markets Act that we have. So these are the largest digital platforms with 45 million users, a market capitalization of 75 billion euros. they cannot benefit from data sharing. They are entirely excluded. So again, sort of protecting the small ones and excluding the big ones to mitigate market power issues. Now, still, if they cannot resolve the price of data, then there are specific dispute resolution bodies and other competent authorities designated at the national level. There's a sort of a sister act specifically for financial data access. Now, a lot here is the same, so I won't go too deeply in it. But just interesting part there is that they mandate the setting up of sectoral data sharing schemes. So this is financial data, so maybe insurers should get together and set up an insurance data scheme. Same with transaction data from investment banks, say, and so on. And this involves not only data holders and users, so other firms that want that data, but also consumer associations. And the scheme must then figure out compensation, not on a day-to-day basis, but as a sort of formula or methodology, saying, look, this type of data must be remunerated in this way. And that must happen on comprehensive market data. That's why it's useful to have everyone in there, because then you sort of have precedents or models for what data might cost, how much it costs to produce it, share it, and so on. The other innovation of this scheme is that, well, maybe these schemes don't get set up. The big insurance players don't want to get together, or they get together, but they don't come to any kind of sharing scheme. In that case, the European Commission can just step in and do it instead of them. And this is, of course, a good stick behind the door. If you don't do it yourself, someone else who knows much less about the sector will do it in your place, and presumably on terms that you maybe find less advantageous. So to sum up on these data acts, the focus is very much on private bargaining, right? It's up to the parties, but it starts from a legal obligation to share data. So the discussion can immediately move to compensation within a FRAND framework that leaves quite some leeway. There should be a margin included as an incentive to come to the table in the first place. And of course, there's this backstop of the European Commission stepping in. Moving on then to a second model. This one is perhaps a bit more known already, and that's these bargaining models between platforms and publishers. We've seen them around the world, as I said. And the basic idea is, again, a market power idea. We have one party that's very strong, the main platforms that show news content, mainly Meta and Google, at least in many parts of the world. And on the other hand, publishers, some big news organizations, Fox, for example, or the Murdoch Empire in Australia, but also a lot of small local news and so on. And if they have to bargain for the remuneration for their news content being shown on platforms, well, they'll likely walk around with a price of 0. That's what we've seen. But the drafter of these acts believe that if this was an equal situation, there would be a remuneration. After all, these platforms benefit from that news content. They show ads against it, for example, and even beyond that, it makes the platform more attractive, a platform that has quality news. So what these bargaining models did, and I'll start with the Australian one, is basically institute sort of escalating mechanisms to drive platforms and publishers to the table and bargain sort of in an equal way. In the Australian one, first, the big platforms can be designated as sort of gatekeeper platforms for news content. They must then bargain in good faith. If that doesn't work out within 3 months, so pretty strict timeline, they go to mediation, and if that doesn't work out, they go to arbitration. Arbitration is interesting because there, again, we see somebody else setting the price, and that happens in a form of baseball-style arbitration. Basically, the platform says, we want to pay so much. The publisher says, we want to pay as much. And it's the arbitrator that decides between the two. Now, it's a bit of a soft form of it because the arbitrator can also show something in the middle. But at least this gives an incentive to come up with a fair proposal. It hasn't been used yet. Even in Australia, no one has been designated as such a powerful platform. But a lot of bargaining has happened in the shadow of this code. It's, again, more a stick behind the door than something that's actually used. And that's fundamentally useful. You want to leave it to private bargaining if they can do so. The private bargaining is helped as well by collective bargaining by publishers. So the authority, the competition authority in Australia, gives specific exemptions for publishers to get together. Normally, of course, competition law looks upon that with a lot of suspicion. It's basically a cartel agreement if you get together with other publishers to price your content. That's simple price fixing, but here it is explicitly allowed. So it's a useful stick. The problem in Australia that they've noticed is that you have to constantly wave the stick around, and even then, over time, it loses its deterrent effect. Facebook, for example, after paying publishers for a couple of years, has said, you know what, we're going to stop showing news altogether. At that point, there's nothing left to be remunerated. The act, compels a type of remuneration when news content is shown, but when it is no longer shown, that's the end of the road. So now they're already talking about more of a taxation levying system. I'll just skip to the EU, where we've done something different or similar in a different way. We adopted or clarified the property rights of press publishers. The Copyright Directive in 2019 said, look, there's also a neighboring right in your press publications to be remunerated by digital platforms. And that remuneration is specified at the national level. France was one of the first countries to do so, and sort of in the most comprehensive way, saying there must be a remuneration for showing these press publication. Collective bargaining is allowed, and even already given some guidance on what should be remunerated exactly. Again, what Google did is similar to what Meta did in Australia. It's saying to the publishers, well, we're going to stop showing your content at all unless you agree with us that the fair remuneration is zero. Now, so again, one way to deal with this legal framework, and the problem was that the legal framework itself didn't have a lot more. There was no adjudication foreseen. So it was the National Competition Authority in France that took up this case instead and say, well, look, we're going to be the adjudicator of this because this remuneration of zero is abusive. It's an abuse of market power in our view for different reasons. It's unfair. It's a circumvention of a law that's on the books. It is also discriminatory because, of course, discrimination means treating different situations differently. And if you pay everyone zero, well, that is in itself discrimination. So it was the competition authority that said, well, look, clearly we need a system here, so let's build that. And it was built really in a series of decisions. First, there was an interim order, then a non-compliance decision with a fine. Then later, when Google still didn't comply, there was commitments. When Google didn't comply with those, there was a non-compliance with the commitment decision. So this whole saga took years, but I'll just get down to the core of it. It was an obligation from the authority and later a commitment to negotiate in good faith within 3 months. Otherwise, you can drag it out. Importantly, there was a lot of information obligations. So if you're a publisher, how do you know what your content is worth when shown on a platform? Well, you know that ads are being shown against that content, so maybe that's part, but you don't know how much those ads go for and everything. So Google really had to give a lot of information to publishers for them to figure out what their content was worth, which I think is something important to stress here and will be important in the AI space as well. Over time, this got more and more detailed. So which type of publications are eligible for remunerations, which one aren't. Google tried to exclude certain ones. Which types of ad revenue matter? Is it only the ad that is right next to the news article? Or is it also the revenue Google gets from just having a more attractive service because people know that news can be found there and so on? And they had to, in the end, also put arbitration in there as a backstop because competition authorities don't like to decide what the right price is. They don't like to engage in price setting, but an arbitrator they felt more comfortable with appointing. So in short, some fundamental limitations here, as you can kind of see. There's an underlying question, of course, or discussion rather, with Google saying, well, this content is not worth anything to us. We're fine without. Or at the very least, any value we get is actually remunerated by showing their content. So they might get some clicks. But that's for another day. I'll go to the third model here, and that's excessive pricing. Classic competition law abuse, at least in the EU. For example, in the US, excessive pricing doesn't exist. The whole point of monopoly is that you price like a monopolist. But in the EU does give us an indirect way of setting prices because under this doctrine, authorities, courts don't say what the right price is, but they at least tell you when the price you set is unfair, is wrong, in other words. And the test they have for this kind of goes back to what the economic value is. Does it have no reasonable relation to that economic value? Then it is excessive over time. This was kind of put in a more administrable test, where you first have to look at the margin. If a firm is getting a very high margin, that's of course a strong indication that the price might be excessive. But then you have to also compare it. Maybe this firm is just very efficient somehow. Is its price appreciably higher than what similar firms charge in other markets, or what the firm itself charges in other markets, or what the firm has charged in the past? There's no fixed comparator here, but you do look at precedents. And an interesting aspect of this is also that the method of pricing matters. Some of the case law has said that, look, if you have a more precise way to price that is equally cost effective, that doesn't cost you more as a firm, you have to apply that method. And most of these cases that we looked at, especially, were about royalties. So just to make that a bit more practical, take a case or a set of cases from Belgium around the collecting society there called SABAM. Place close to my heart because I am from Belgium. But of course, collecting societies tend to have market power. All artists tend to, at least within a jurisdiction of one nation, belong to the same copyright society. Sometimes this was a statutory monopoly where the state said, this is going to be our collecting society. Sometimes it's simply because it's most efficient for one society to do this and have all artists with them. Now, of course, that opens the door to abuse, and that was the case. We're a big festival country in Belgium, but festivals owed a lot of their revenue to SABAM for, again, playing music, of course. And they had a very inaccurate rule. It was the 1/3, 2/3 rule. If less than 2/3 of your music belonged to the repository of SABAM, then you owed 2/3 of a certain percentage of your revenue to SABAM. If it was less than 1/3, then you owed 1/3. Even if it was only 5%, you still owed them 1/3, in other words. So quite imprecise. And at the same time, they were also increasing what they took from that revenue with 37%. So pretty significant. Both of these were found abusive by a Belgian court based on this guidance from the European courts. So again, no direct price setting. It's only saying what is unfair. Now, of course, if the 37% increase is unfair, you know that will have to be less. So there's some guidance there, but no direct price setting. I think that the part on methods, on forcing price setters with monopoly power to be accurate in how they price things, is perhaps the most important part of this case law. Moving on then to the last model we went into, and I promise to go back to AI in just a second, that is the pricing of these standard essential patents. Now, standard essential patents are interesting. Basically, we like technologies to be interoperable, and that sometimes means implementing the same technology, say Bluetooth. Of course, that technology might itself be patented, so then others need to implement that patented technology, and there needs to be a governance mechanism for that. This is usually done through standard development organizations that designate a certain technology as the one they'll converge on. And of course, that patent is then subject to a FRAND obligation, saying, look, we're going to go with your patent technology, but you have to license it out on fair terms. This is to mitigate some risks, because there's risk on two sides here, interestingly. Both the owner of the patent and the implementers of it might have some power, depending on who they are. Hold-up risk is perhaps the most known. This is when the patent owner says, well, yes, I committed to license on FRAND terms, but you can't have my patent unless you pay me a ridiculous sum or under very restrictive conditions, and so on. And of course, once that patent has become part of the standardized technology, others kind of have to, so they might indeed be tricked into paying very high fees or under restrictive conditions and so on. But the opposite can also happen. The patent is already out there, it's part of a standard, so others might start implementing it without paying anything and say, look, if we drag this out long enough, maybe that partner is in a tough financial position, at some point they'll agree to maybe very low fees or even a zero fee. So the Court of Justice of the European Union came into this and said, well, we're going to organize this bargaining so that we can ideally mitigate those risks of both hold up and holdouts. Basically, much like in the bargaining models, we're going to say who does what at what point. First, if there is an implementation of such a standard essential patent, the holder of that patent has to alert the infringer. Maybe they didn't know that they were implementing a patent technology. If the infringer is willing to play, willing to come to the table, then the holder of the patent has to make a first offer. And importantly, again, say how they made that offer. Include the method of calculation. What is it based on? Is it based on the price of their development, or is it rather the price of the product that the patent is implemented in? There's a lot of different methodologies that are possible there. If the infringer then doesn't like that offer, which is perhaps quite likely, they do a counter offer that also has to be framed. And if they can't find a solution, they appoint a third party, for example, an arbitrator, but they can also go to court. So it's kind of a structured way of ensuring that bargaining happens in good faith and ideally comes to a price that is fair. Now, bargaining doesn't always work. And then, of course, courts are one option. We have seen courts in the UK specifically being quite willing to set rates that are framed. So this is one of the very few instances where we see courts not just saying what the wrong price is, but actually putting a price, a dollar or euro amount on it. And they do so mostly based on comparable contracts. They sort of go back and look at all contracts that are somewhat similar and that are untainted by this hold up or hold out, and then use their evaluation and judgment to set a framed rate. Of course, this becomes a bit fuzzy, but since they're courts, they're comfortable enough to do so. It is, however, a very costly process. If you look at these cases, they ran over weeks and weeks. A lot of very expensive economic consultants worked on these cases. They had experts' reports, but also just thousands and thousands of pages of contracts that they had to go to from other friend negotiations and agreements. So this is only reserved for the most deep-pocketed of players. Large car manufacturers have a lot of this litigation going on, for example. However, litigation is only the top of the iceberg. Again, a lot of agreements are actually reached in the shadow of this bargaining system for SCPs. So it is useful to have a case from time to time, also because once one party is sort of holding up or holding out, the judges take that into account and will kind of penalize them for them. So that gives other parties a signal that they might not want to do so because the court will not look friendly upon that. Again, we included this because it's useful to see a system where the courts in this case actually set a price based on a predictable methodology of comparison again. Now, this leads to sort of inductively a kind of system like what are the things as a policymaker, as a lawmaker that you should really consider if you want to set up a system where AI developers and content creators bargain for remuneration. First, you need to set kind of a goal or a protected interest. And here you might go in one way or the other. Is it a societal goal like innovation, or is it one party that you want to protect? Often you will need an incentive to bring parties to the table, especially those that have access already to the other's content, whether that's a standard essential patent or news content. Well, they have what they want. They don't need to come to the table. In other cases, of course, collecting societies, for example, well, both parties will want to come to the table because it's profit maximizing for both of them. Then perhaps the important part, you need a pricing criterion and ideally a process to implement that. A lot go with kind of a FRAND-like prescription. I've talked about that. Good faith obligations are important. And then especially the last two ones are a bit more prescriptive in what the pricing should be based on. Most systems somehow try to mitigate market power. Sometimes that's by differentiation of fees, like in a data act. Often it's collective bargaining or collective management, which is a way of collective bargaining. And finally, what's the backstop? If it doesn't work out, if parties have come to the table but they don't agree, you need to give it delegated to some third party. Often that will be a dedicated body, a court. Sometimes the European Commission wants to step in, like under Data Acts. Mediation and especially arbitration are also popular options. So these are things we think should be part of an AI remuneration system. Now, even though this is a bit of a work in progress, I'll try to go one step further and give a bit of an indication how we might apply that to AI training. Because the protected interest, well, this is a policy choice, right? Where do you want to put the balance? Is it for AI developers? Do you think this is such useful technology that actually maybe a zero price is fine? Or do you think, well, content creation is something that is socially desirable, we want to protect that? And here, I mean, it's the reality on the ground that matters. Who has access already? Well, most of the content has been crawled by big AI developers. So they're obviously the one with a stronger position here. That maybe gives you an argument to rebalance it in favor of content creators, because technologically they're not really able to do so. I mean, they can stop crawling, but now we've already seen AI developers getting around those restrictions. So putting it on that side, which we think is fair, might lead to protecting that interest in a way that the price range is at least from non-zero to whatever. And sort of the limit there is making AI training itself unfeasible. Now, you do need an incentive to bring it to the table, again, because most AI developers, at least the ones that have been in this market for a year or two, have crawled all the content. And sure, there's still new content where they can be blocked from, but the access has clearly benefited them. And they might not sort of see it as necessary or profit maximizing to come to content creators. Maybe the very largest ones, I've pointed out some agreements, but not all of them. This we know from precedents with news content. Meta has always argued it doesn't need news. Google kind of the same. Now, some academic research actually says that platforms are very much harmed when they don't show news. Engagement goes down by up to 10%, which is problematic. But we very much see the same arguments returning in the AI space. Saying creative content, well, is not very valuable for us. We'll still have enough even if all the other ones pull out. So that's something to tackle. That means, if there's no natural incentive, you probably need to bring them to the table with a stick behind the door as well. On the criteria and the procedures for price setting then, we've seen different options, but the economic value is likely a good starting point. I mean, this, at the end of the day, should be something like a moderated market exchange. Of course, economic value is very difficult because there's so many different types of content. What is the unit that you remunerate? Is it a token? That's, of course, the technical AI training unit. And apparently, if you believe Kevin Scott, Chief Technological Officer of Microsoft, they have a better and better understanding of what each token is worth for training. So economic value is maybe something you can get to, at least if you get insight first into, well, the internal operations there, what do they know? But also if you get insight into the agreements that are already out there. So use comparison methods. We have at least 82 deals out there. If you get those together and see what they are based on, and we can't because they're secret, that might give us some really good comparisons. Finally, on market power, or next to finally, well, a lot of methods, but I think fee differentiation is promising here. Maybe the large commercial developers, especially the ones that are already strong in other markets like Google, those pay, and the smaller ones, the non-commercial ones, the startups don't, because we do not want to limit innovation in this market either. Of course, you then need to differentiate who is small and who is large, but we have a lot of acts that have already done so. The AI Act works with floating point operations of models. DMA perhaps a bit simpler with its gatekeeper concept. And we do also see a real role for collective bargaining and perhaps management, because a lot of the types of content that are useful here, from music to film and TV to, of course, press, already have collective management societies. So obviously giving it to them as a sort of collective bargaining point is interesting. You would probably have to authorize that specifically, because otherwise competition law would find that cartel-like. And you do need to come up with a backstop. What if everything else doesn't work? What if the sort of market exchange, even with a little push in the back, doesn't work? Well, then giving it over, not to courts and administrative enforcement, we think, because those are so costly, but rather to perhaps arbitration, but ideally a settlement body that can build up expertise over time. And at a high enough level of scale that they get to see a lot of these disputes and a lot of the comparison agreements, perhaps in a closed door process, because they're very careful not to get those details out. That might be the way to go. So I'll just conclude there and then stop to move for questions that you might have. Thank you very much.
Thank you for this insightful talk. Gives a lot of food for thought, I think. I'll open the floor for questions, and I also have some, but I'll reserve them for later.